Assalamualaikum and welcome you all. Students, today is the new class and the lecture number 14. And in this lecture, students, we are continuing our further course towards the remaining topics which we are going to complete by the next week. So, in this lecture, students, the topics we will discuss because we have already completed by a previous lecture the substantial part of the international criminal law. Now, this is the last and third part of the international criminal law. What is the future of the international criminal law? So, in this part, other than the core crimes, which we have already discussed in detail, so other than what will be the other crimes which international courts and the international criminal law will cover other than the core crimes which we have discussed. So, students, here's the in the future today's class and future class, which consists of week number 14 and 15, lecture number which also lecture number 14 and 15. So, what will be the topics and what will be our lesson plan, what we will learn in these lectures? We will cover the future international crimes, which are the transnational crimes, terrorism, corruption, torture, and thereafter the introduction of the Corruption and United Nations Convention on the corruption, and thereafter lastly defenses under the international criminal law and immunity. So these are the remaining topics which we are going to learn in the lecture number 14 and the lecture number 15. So in the lecture number 14, students, in this lecture, the lesson plan of the week 14 is the what is the future of the international criminal law, and in this part, the topics are the transnational crimes, terrorism, torture, corruption. We will discuss each one with the purview of the ambit of the international criminal law, their conventions, and the cases which probably perhaps which cross the boundaries of the states, and which definitely harm the security and of the, and also the development of the state, their citizens in a better way. So that's why these laws has to be discussed and uh, uh, come in the ambit of the topic of the international criminal law. Students, the future of the international criminal law. Today is the first topic of today's lecture. So I'm going to I am beginning my lecture with this topic. What will be the and what are the features concerns regarding the international criminal law has developed at an unprecedented rate since the early 90s. It is therefore too early for us to issue any final judgments, but it is the purpose of this lecture to evaluate recent developments as far as possible and look tentatively to future of the international criminal law. International courts and tribunals, it is a commonplace because it is largely correct that the catalyst for the revival of the international criminal law was the creation of the ad hoc tribunal by the Security Council in the early mid 90s. Although the project for the International Criminal Court had received same increased attention since its uh, re-inclusion on the General Assembly's agenda in 1989, this was not seen as likely to bear fruit. The creation of the ad hoc tribunals, on the other hand, showed that such tribunals could be established in reasonably short time, and the focus of the debate shifted from the question whether such tribunals were a realistic possibility to how they could be improved. The ad hoc tribunals have been criticized almost from the start as being expensive and bureaucratic, as well as producing what some consider to be short trials. Therefore, these experiments have to be credited not only with a reasonable level of success in their own proceedings, but also with providing the impetus for the creation of what many thoughts was a near impossibility in the international legal order, a permanent international criminal court. So it was the footstone towards the creation of the International Criminal Court. At that time, that was the future of the international criminal law. The progression from Nuremberg to International Criminal Court has been described as long road ending in the zeal of the Rome Conference. Therefore, the frequent use of title from Nuremberg to the Hague is writings in international criminal law. That is the reason. It has often been claimed that international criminal court will lead to the end of impunity, and it has been held as something of the panacea for the international ills. But the euphoria which accompanied the adoption of the International Criminal Court statute has given way to a hard-headed, sometimes not create as supranational criminal law enforcement regime. It does not create a self-contained police force to investigate international crimes or to enforce its arrest warrants. As such, the investigation and prosecution before International Criminal Court may often occur against the backdrop of these situations of the extreme practical and political difficulty. And moreover, the International Criminal Court Statute has not been universally ratified, and a number of states are either reluctant about or opposed to International Criminal Court. Although the United States has become more supportive of the court, some African states appear to be cooling in their relationship with it. That said, given the frequently attends treaty ratification, most supporters of the International Criminal Court would not have dared to predict that about 110 states would have ratified the International Criminal Court statute by 2010. Early fears that only stable Western democracies would ratify, little, leaving the court with little to investigate, have also proved unfounded. The first trial are proceeding, and uh, there's evidence that they are having a deterrent effect. The developments of the international crimes ought not be forgotten that the site of most international criminal law enforcement is not intended to international courts. International tribunals have arisen because of the failure or the absence of national justice efforts. They are not meant to replace them. One of the major role which international judicial mechanism have its promotion of the more effective use of the national criminal justice systems. The international courts and tribunals cannot deal with any but a handful of the cases, and the national system must take a greater part in the prosecution of the international crimes if international criminal law is to be effectively enforced. This is particularly the case for the International Criminal Court. The principle of the complementarity. It is sometimes said that the International Criminal Court will have succeeded if it never has to prosecute anyone itself. Such assertions are overstated. If all the court did was to oversee domestic jurisdiction, it would rapidly be seen as an extremely expensive way of doing so. So, therefore, there's a great deal of truth is the claim that a major role of International Criminal Court is to ensure that domestic jurisdiction act against the international crimes. The role of the prosecutor is structured so that the court can act as a considerable incentive to states in ensuring that they prosecute international crimes and where it is appropriate, assist them in doing so. This includes the passing of the evidence and expertise. The prosecutor has stated that the policy of the Office of the Prosecutor is to engage with the governments to ensure prosecution of the crimes within the jurisdiction of the International Criminal Court. In addition, ratification of the ICC statute has prompted a reasonable number of the states, although not enough to adopt domestic criminal legislation governing the core international crimes against the background of these states traditionally failing to implement international crimes into their domestic law. Is itself a development worthy of note, which state have been cooperating with one another and prosecuting international crimes may, it is hoped, becomes less significant with the conclusion of new and more effective agreements on interstate cooperation, including those at the regional level. The situation at present, though, cannot be described as satisfactory. So, next topic is the trend towards the accountability. In a statement released just after the Rome Conference, which adopted the statute for the International Criminal Court, Amnesty International claimed true significance of the adoption of the statute may well lie not in the actual institution itself in its early years, which will face enormous obstacles, but in the revolution in legal and moral attitude towards the worst crimes in the world. No longer will these crimes be simply political events to be addressed by the diplomacy at the international level, but crimes which all states have a duty to punish themselves or if they fail to fulfill this duty by international community in accordance with the rule of law. This assertion contains more than a grain of the truth. The creation of the International Criminal Court reflects and contributes greatly to a significant cultural turn to accountability. 15 years ago, most of those accused of the international crimes could sleep soundly, fairly, sure that they would not be required to stand trial for their conduct. It is unlikely that the uh, international law would be brought to bear upon them. Both to different extents have been proved wrong. Even if one on the basis of what had occurred since Nuremberg to Tokyo, their opinion had an empirical basis. The ad hoc international criminal tribunals may well have been created out of motives that were at best mixed, but the idea they contained, that of accountability for the international crimes, was one which caught on. Ideas are important in international relations. And further, uh, more our students, the last topic of the future of the international criminal law is the development of the international criminal law. International criminal law is a relatively new discipline and it does not pretend to be a complete system of criminal law. It is not intended to be a replacement for the totality of the domestic criminal law. And there's no reason why it ought to be. It has inconsistencies and incoherencies that are the result of its formation in political negotiations. Moreover, within the parameters of the international criminal law, the international criminal court statutes is not the final word. Some have presented it as something close to definitive, even where it is controversial. But Article 10 of the statute itself recognizes that the law may continue to develop. There is scope for the further development within limits by courts, including International Criminal Court, although the International Criminal Court's imperative mandate is more hemmed in than others have been. These considerations raise the possibility that the different bodies of the international criminal law will apply before different tribunals, and there will be consequent problems not only of the coherence but also in determining the precise customary position on the controversial part of the international criminal law. This problem arises both the criminal tribunals and the International Court of Justice in the context of the state responsibility. There are areas of the divergence on the substantive law between the founding documents of the ad hoc tribunals and the International Criminal Court statute. And although the ICC has shown respect towards the jurisprudence of the ad hoc tribunals, there are already some significant differences with respect to the substantive international criminal law. On, for example, genocide, joint criminal enterprise, and superior responsibility, there are also differences between the international law and some national laws. This is unfortunate, although it must be said that more evidence there's more evidence in support of the propositions of the customary international law than was the previously the case. Some of the remaining problems can be mitigated by careful study of law, which involves an appreciation of the relative authoritativeness of the various sources and evidences of the custom point. That said, between the late 1940s and early 90s, international criminal law was a field of law which was rarely seen as the relevant of by many international lawyers or governments, and which was rarely studied or written on, let alone taught as a separate subject. Now it is a major area of study and practice. 20 years ago, few would have thought that a textbook like the subject like this would be useful and necessary. Even less would it have been thought that the developments in international criminal law would warrant us less than half decade. It is our hope that by adding understanding of the law, this course will contribute in a small way to objectives of the international criminal law as a whole. The bringing to justice, and finally the deterrence of those responsible for the atrocities that continue to plague our world. Means uh, plague or seed the hatred which caused the biggest destruction already occurred. And if this law will flourish and United Nations will play its role correctly, fairly, justly, and rightly, then then the true fruit of these treaties, laws, and these courts will be helpful in order to maintain the peace among these states. Is we are well aware that if if there's a slightest, if there's a uh, not only slightest in a large scale, there's an injustice anywhere in any part of the world, is the threat to the justice everywhere in the world of the those citizens, people, they are living in a peaceful manner. It doesn't mean now we are living in a peace and we are living in a safe society, uh, but the after shocks, but the effects of the injustice anywhere in the part of the world definitely will shake those societies. They are living in a peace, they are living in a safe corner. So if there's any injustice happening in anywhere in the part of the world, it has to be addressed, and justice should be given to those peoples. Now they are facing the hardship of the life under the regime, under the sponsorship of the states. Those are the responsible, and their personal agendas. and they are thinking like that they may live, but other may not live in that world. So this principle, this frame of mind, will definitely harm the society. So it was the introduction of the international development of the future of the international criminal law. So after this, students, we are moving towards the our next topic, that is the